Well, when U.S. Supreme Court justices return from their winter holiday, they are taking on several key cases, including multiple cases that tackle First Amendment rights. Chief Legal Analyst Rhodes is here. I mean, there is a lot to talk about with this. When we talk about the First Amendment, of course, one of the big ones a week from tomorrow is the TikTok, whether this is the ban on TikTok being challenged. What can you tell us?
This is a First Amendment argument, clear as day. The biggest argument is that, and folks have to recognize this, the federal government can attempt to chill your speech, but it has to do it in a number of ways. Specifically, it has to be a compelling public interest in this situation, and it has to be narrowly tailored. And this is the argument that TikTok is making, is that there has to be another way, that this is not the most narrowly tailored way. And what is your compelling public interest? The government will say the compelling public interest is national security. Okay, we agree with that. But is there another way to stop the national security issues or interests that you're seeing that's out there without forcing us to sell the business? And you may say, well, they're not talking. This isn't speech. Well, speech isn't just you speaking. It's also your ability to access information. The First Amendment goes both ways. So they're saying not only are you stopping us as a company for exercising our First Amendment, but you're stopping our users, content creators and users from getting First Amendment access. And so that argument, I think it's novel, but I do buy the fact that this is something that we have not seen before, where the U.S. government is forcing a company, a social media company specifically, to sell, and if it doesn't divest, then the company will not have access to use the internet in this country. I think this is going to be a major case in terms of First Amendment, and the implications could be lasting for years. I
can tell you there's a lot of young people that every time we talk about this, they pay very close attention to what we're talking about with if it's going to be a sale or a ban. Okay, going on to the next one. Big question again now over the Texas law requiring adult film websites to require proof that the person accessing them is of age to be able to do this and not underage. So give us the details.
Not just Texas specific. This will have reaching implications as well. North Carolina implemented that same thing, and it banned a number of porn sites because they would not implement these stricter restrictions, specifically making sure that you verified not just on the site, but having a third-party verification where they would actually allow you to upload your identification. They'd verify it, and then they let you access the site. That extra step, that extra hurdle is what the people in this lawsuit is saying is a violation of First Amendment. Because again, you're putting some extra barriers in front of my ability to consume information. Even if it's an information that some folks may not agree with, it's still information. And because it's information, I have a First Amendment right to access that information. And if you're adding hurdles to my ability to access it, yes, you're trying to prevent children, but in the process of preventing children from getting access to this site, now you're preventing adults from getting access to the site, and you've added this extra hurdle. That extra hurdle, back to the original statement, is that the most narrowly tailored way of you getting there? Could it be another way for you to stop children from getting access to the site without preventing adults from getting access to the site? First Amendment argument. I think this one goes in the favor of the folks that are bringing a lawsuit against these states because it is extremely preventing adults from getting there, and it's not narrowly tailored, more so than the first one for sure.
Do you think we're going to get surprised on this one?
I don't think there will be surprise. I mean, the famous Supreme Court case says that when talking about pornography, you'll know it when you see it. This is, I think, a clear example of a First Amendment violation where the states are adding extra hurdles and they haven't been narrowly tailored, and I think the states will lose in this case.
All right, Rhodes, appreciate your insight as always, and Happy New Year to you.
Same to you.
Yes, all right.